So I now request Mr. Mahesh Chand Gupta to introduce our chief guest, Justice K.R. Jinan.
Okay. Thank you, Vivek. I'm fortunate and honored to introduce none other than Mr. Justice K.R. Jinan, who is very well known in the NCLT sector, where I have opportunity or to appear before him when he was in Calcutta bench. Now he was in Calcutta bench only from 2017 to 2020. It's before formal introduction. I remember how he was so well handling the matter. Like today, he was always in the bench or court also. Even for these very critical matters or very aggressive discussions, by his smile, he was able to uh, uh, dilute everything. So is very much still energetic, enthusiastic, and very much helpful in understanding IBC. And he was helping people, even young practitioner at that time. He was encouraging them, even for small mistakes. He was not ignoring that and trying to explain them how to do it. So that was the beauty of Justice Jinan. Now, coming to formal introduction, he was born on 29th August in 1955 in a small village of Kerala. And by his, as I said, by his hard work and energies, he could complete BSc in Zoology in 1978 and then did LLB, bachelor's degree, and then master's degree from Government Law College, Ernakulam. After passing, he joined practice as law advocate in High Court of Kerala. Then he joined many other legal luminaries, and finally he was with the Judicium. He presided over the various judicial forums, and finally retired in 2015 as the chairman of the Munnar Special Tribunal. After his retirement, he joined as a judicial member in NCLT Kolkata bench from 2017 to 2020 and continued. Now he's continuing his law practice in Kerala High Court after retirement from the NCLT Kolkata bench on his attainment of retirement age of 65 years. So we have today, it's a great moment, great opportunity. Justice Jinan is with us, who has got 31 years of judicial experience. Now I'll request Justice Jinan to enlighten us on his views on the topic handling disciplinary so-called notices, proactive solution guidance on how to prepare, respond, and resolve regulatory issues effectively. Over to you, sir.
Very good afternoon.
Yes, sir. Jinan, sir.
Yes, sir. Yes, I am here. Thank you for a review or a recollection of my profile by Mr. Mahesh Chandra. Thank you so much for remarks which I would like to upgrade by myself. I am not sure why can I reach up to that remarks. Thank you so much.
Thank you, sir. Thank you.
Mr. President, Ashish Mahajia, IPNet. I think I am correct, Mr. President. Ashish, I didn't see him. Mr. Nibuns.
Ashish Makhija is
the IPNet president.
The speaker today.
Am I correct? Oh, okay. Fine.
IPNet is Mr. Ashish Makhija.
Okay. Ashish Makhija. Okay. And I truly remember him too also. Mr. Nibir Sinhavi, the lead faculty leading today's webinar on handling disciplinary show cause notice. And Mr. Mahesh Chandra Gupta, who is reminding me about your webinar repeatedly and just before a few minutes. My dear brothers and sisters, it is great to see some of very familiar faces here. Certainly, I can refresh the name from the list, but I did not naming for the saving the times. And at the outset, I would like to thank Mr. Rahul Parasuram Puria as to introducing me to you. I think that for inviting me to deliver a keynote address before a unique audience of
Yes, sir.
insolvency prevention of IPNet.
Yes.
His face is also familiar to me. Truly, it is an absolute pleasure and a profound honor to address this esteemed gathering from Calcutta today. As I sit before you, I am reminded of my tenure. You already let in about me, my tenure as a judicial member of NCLT Kolkata, and the members of the NCLT Kolkata Bar Association headed by Sri S.M. Gupta ji, the president of your Bar Association, and Srimati Mamata Binani, the then vice president of the association. Without naming them, I think that I could not start any speech before you all. I am really proud of you all, truly. The years I spent in Kolkata were the most memorable days in my life. The experience I got from you all is great. With these few words, I may begin. Something about the IBC. Since in inception in 2016, we were there. IBC has resolved about 3 and odd crores, lakhs crores of debt stuck in 808 cases in 7 years. As on March 24, it has resolved a significant amount of stressed assets with better recovery rates compared to previous mechanisms like the Debt Recovery Tribunal, the Securitization and Reconstruction of Financial Assets and the Enforcement of Security Interest Act 2002, and Lok Adalat. This highlights a significant behavioral change among the borrowers, showcasing the efficacy of the insolvency and bankruptcy code in encouraging timely settlements. Now also settlements are improving and increasing. When the efficacy of IBC increases, opportunity as an insolvency professional like you all also increase. So it is time for you all to grab the challenging opportunities in your career as insolvency professional in the coming future. With these few words, coming to the topic you are going to deliberate on today is unique topic, namely proactive solution on how to respond and resolve in disciplinary actions. You have invited me to address the protections you are expected to take in facing disciplinary proceedings by IBBI. I think you wish to learn how to make your defense against the proceedings, if any, to be taken by the IBBI. It is a unique demand that is difficult to explain. However, I try my level best to share my thoughts on the given subject to me. First of all, I would like to convey to you that prevention is better than defending an issue. What I mean is that you have to be well prepared for the provisions of the code, abide by the code of conduct specified in the first schedule to the IBBI Insolvency Professional Regulation 2016, IBBI Circular Code of Conduct defined under Section 208 of the Code. Because you are not booked by the IBBI either suo motu or on complaint from agreed parties to CARP or liquidation process, or on the basis of orders of the tribunal, or by forwarding complaint from tribunals or from CBI alleging violation of the provision of the IBC code or breach of code of conduct. I stress violation of the provision of the IBC code or breach of code of conduct. I repeat, if you are with due diligence doing your job assigned to you, you take reasonable care. I stress reasonable care, not an expert or your expertization care. No, you are expected to take reasonable care while performing your duties. You meet all the requirements provided under the bylaws of your insolvency professional agency, giving access to insolvency professional agency to inspect your records. Not defaulted in submitting copies of all proceedings to adjudicating authority, to the board, and to your agency. Meet all requirements to be met under the code, rules, and regulations. You will not give a room for challenging your service by any person or authorities. Nobody can raise a challenge against you. Even if you booked, if you can satisfy that there is no default, there is no breach of service conditions on your part, you will be exonerated even if a disciplinary inquiry proceedings has been initiated against you. I have gone through the IBBA website for my own understanding about the number of disciplinary proceedings so far initiated by the IBBI as against the insolvency professionals from CAs, CS, and cost accountant and lawyers. Interestingly, I did not see any cases against the cost accountant by the IBBI. Maybe because the number of cost accountants registered with IBBI is 5%. And also there is no case book against the lawyers whose registration comes to only 6%. Out of 4,352 registered insolvency professional, I think it is up to 2024 March. 55% are chartered accountants and 75% only come to company secretaries. So these are the percentage of participations from your professionals. So booking of cases against the cost accountant and the lawyers are rare. Rarely, I think that not seen in the published website list, but majority are coming from chartered accountants and a few from company secretaries. So also it is interesting to note that the number of disciplinary committee from the year 2017, disciplinary committee first started in the year 2017, and it go up to 7 committee in the year 2024. Only one committee was there in 2017, 2 committee was there up to 2020, then increased gradually, and now in this year 2024, I check it, only come to 7 committees has been constituted. What I understood is that each disciplinary inquiry proceedings, one committee has been constituted. So that also I have also looked into the power. You also, it is good to understand the powers and functions of the board under the IBBI. You are all well aware that how the disciplinary proceedings has been initiated under the power of insolvency IBC code. Section 217 to 220 are the relevant provisions. Upon receipt of complaint from any aggrieved party, the board can initiate proceedings against any of the professionals. If found reasonable ground, issue direction to investigate to any professionals or any or agency, and on receipt of report, only investigation authority, the board, having prima facie opinion that sufficient cause exists, has to issue show cause notice. So on getting the report from the investigating authority, if board is satisfied there are sufficient cause and there is prima facie opinion that sufficient cause exists, then only show cause notice under section 219, read with regulation 11 is to be issued by the Disciplinary Inquiry Committee. Upon receipt of reply to show cause notice, the board appoint I am only on getting the report from the show cause notice only, a disciplinary committee with whole-time member only is appointed. Under section 220, committee if satisfied, sufficient cause exists, impose a penalty. It can suspend, cancel registration, it can impose penalty 3 times of the loss cost, up to three times of the loss cost. If loss is uncertainable, the penalty is limited to not to exceed 1 crore. And if the loss to be compensated has been recovered, it goes to aggrieved party. So these are the powers vested on the board under the provisions of the court. I have also gone through various case laws determined by the IBBI. When I gone through the case laws, I find there are certain irregularities, there are certain omissions from the insolvency professionals. There are some breach of code of conducts from the insolvency professionals. Are the grounds enable the complainants to raise a complaint against you, and IBBI, after sufficient inquiry, on prima facie finding, booking the insolvency professional for disciplinary inquiry proceedings. I may summarize around 19 grounds. Certainly, as of now, the insolvency professionals were challenged. Their conduct has been challenged, their career has been challenged, their services were in challenge. Mainly, repeated offense committed from the side of the insolvency professional is coming to non-appointment of registered valuers, not in compliance of regulations 27. You are well aware that 2 registered valuers are required to be appointed, but in some cases 1 is appointed, some cases is not the registered valuer from the list of the IBBI. This is the one among the major cause or major grounds to initiate or get challenge from the individuals or from the IBBI or from the ICAI or from ICSI. The second reason I find, the majority reasons I am highlighting, not obtaining non-disclosure undertaking from all creditors. There may be circumstances more than 2 financial creditors. Some omission is there from the insolvency professional in not obtaining non-disclosure undertaking. That is an irregularity and also an illegality, and it is an actionable offense. There is also delay in submitting final list of resolution applicants. You are also well aware that there is a mandate is stipulated. In one case, the explanation forthcoming from the insolvency professional is that since I published and circulated and submitted provisional list, and there is no difference in between the provisional list and the final list, I did not communicate a final list of resolution. That is bad in law, and you will be you are prone to proceedings initiated by the complaint at the hand of the complainant, or at the hand of the IBBA, or at the hand of your institution even. The next one I come across is violation of clauses under the regulation 7.2, the code of conduct. There are 22 and more old code of conducts you have there. If any one of the code of conduct you breach, certainly it will be a cause of action to sue against you, to raise a complaint against you. So take care of not to violate any of the clauses under regulations 7.2. So also some still, even if we were 7 years ahead of enforcing the insolvency, the IBC court, the still there are some professionals appointing related party. That is a violation of clause 23B of the Code of Conduct. You are very well aware of it. So please don't repeat it. Appointing related party is also an action, is a grounds to initiate complaint against you by the aggrieved party or by the IBBI or by any other institutions. So take care of it. Then there is a failure in updating list of creditors. This is also usual common, or I mean common grounds coming from the professionals, that they are not updating the list of creditors. Maybe is a bona fide error, but there may be some are exonerated in some cases. However, take care of, be comply or meet in stipulated times. So also that overlap in payment of fee is only one or few cases. There are overlapping payment of fees and expenses. That is also not regular. That also bad. Failure in preserving records. Some records after the, I mean, sometimes in some cases there are lapse of many years. So keeping records may be impossible with him. But however, you are statutory bound to preserve records until your tenure, the conditions has been meted out on your end. Lack of reasonable care and diligence while performing insolvency professional duties is one another common ground initiating or common ground for initiating disciplinary inquiry proceedings against you. Lack of transparency with respect to appointment of professionals. Take care of it. Not preparing invoice properly. The professionals could not be ascertained by inspecting the authority. Who are the inspecting authority? Who are the professionals to whom you have to pay? And the invoices, if not properly prepared, is also one among the cause of action to initiate disciplinary proceedings against you. Demanding legal gratification is only rare in only very few professionals. Challenges are faced by on demanding legal gratifications. So also on one case I find failure to pay CRP dues. I am not mentioning the name of the case and name of the resolution professional. And non-cooperation with the investigating authority in conduct of investigation is also one ground for initiating proceedings. So this is not an expected non-cooperation from an insolvency professionals like you all. You are to keep some dignified. This is a dignified provision. So non-cooperation is certainly not to be expected by any authority, even in your agency or by IBB or ICA institution or ICSI institution. Certainly hard to cooperate with all the investigating authorities without any fault on your sides. Failure to issue notice to operational creditors. In some cases, the section 24 is not to be meted out. You know the required percentage of operational creditors come in. Certainly, you are statutory bound to shall issue notice to the operational creditor. If non-issue is operational creditor, then there are proceedings to be irregular and illegal, and it is bad in law, and disciplinary inquiry proceedings may taken against you if such a default committed from on your sides. Then comes to issue related to resolution bond submitted by a resolution applicant who is ineligible under section 29A. Still, 29A, you are not carefully evaluating who are the related to related party and who are the parties to be exempted under section 29A to be clearly checked it. You can also take opinions from others and to make sure that when you take a decision finally, there may not be any issue related to a resolution plan submitted by a resolution applicant who is ineligible under Section 29. Such an occurrence may not be happened. Certainly taken care of it. Non-filing for application for avoidance of transaction is, I think it is increasing somehow. So you have to take actions for avoidance of transactions. There is also some irregularities. Not only irregularities, because it is a statutory violations if you are not taking any actions for avoidance of transactions. So this is a major cause of actions against you for taking disciplinary inquiry proceedings. The last and the very familiar about you is that lack of due diligence in verification of resolution plans. If you are not diligent in verifying the resolution plans, and some irregularity if it is kept, this also is one among the cause of actions for initiating disciplinary actions against you. These are all the 19 reasons under which some of your professionals were already booked, some were punished by the IBBI, and some, I think that out of around 10 cases were booked by your institutions. 6 cases has been booked by ICAI, and 4 cases has been booked by ICSI, and think that they have penalized that guilty insolvency professional, and I think that larger amount has been levied as a penalty even by the institution. So that institution wise you have to take care of, and IBBI wise you are also taken care of. So two institutions you have to satisfy while you are carrying the profession, a prestigious profession. I would say that a prestigious profession and a dignified profession you are now doing. You are given adequate remunerations. Your expenses has been adequately safeguarded. So that why not you obey? Why not you try to meet all the requirements within the purview of the four corners of the statutes? If you are within the purview of the four corners of the statutes, you are free. Nobody is going to challenge. With these few words, I may sum up. The role of an IP is a crucial and critical to fulfill the objective of the court. It is imperative that insolvency professional functions and discharges his or her duties independently in a fair and transparent manner and facilitate fulfillment of the objective of the court. It is the duty of an interim resolution professional or a resolution professional to perform and discharge his or her duties in accordance with the code and the regulations made thereunder in letter and spirit. If you are within these requirements, I am repeating and repeating, not to fear any complaint against you. Complaint is prone to make by dissatisfied corporate debtor or dissatisfied persons saying that they are agreed party. So don't fear it. So in the light of all these facts, all these thoughts which I can share to you, I would say all the best to all the participants for this virtual meeting. It is an absolute pleasure for me to be here today, and I very much look forward to seeing the growth of IPNet Kolkata. Once more, I extend my hearty thanks to IPNet for giving me an opportunity to participate in your today's webinar. Thank you. Thank you all.
Thank you, sir. I request Sri Ravindra Chaturvedi ji for a vote of thanks to our chief guest, Justice K.R. Bina.
Thank you, sir. You have given me an opportunity to thank our sir who has. Thank you. Welcome, sir.
See your face. I didn't see you. Okay.
Sir, we don't have word to express our gratitude and thanks to you. That we all know that when the NCLT start working in Calcutta, you have since then you are guiding all the IPs, and you are one of the bench members who is always very transparent and supportive to all the IP professions. You came here, shared your experience. It was a great help to all the IPs. Uh, the way you have guided us that how we should work independently with a transparent manner. More so, there should not be any non-compliance from our side. There should not be no one who should say 19.2 to be filed on the IPs. That is the best thing you teach us, and that I also feel. I have also handled so many cases, and the government department always expect that we are the extended arm for them. So we should give all the possible support. That is the best thing you have enlightened us. So I don't have any word to express my thanks, and I really thankful on behalf of all my colleagues who are attending this party, this seminar, and all IPs fraternity, whom you always shower your knowledge and in this our help. Thank you so much, sir. And I request Vivek sir to share the memento, please. So this is from our side, and I will try to come and give it to you at your residence only. Whenever I keep visiting Kochi, sir, it will be my privilege to again have a idli of Bhabiji that you had offered me last time. So I will come and give it to you in person whenever I will be in Kochi, sir.
Oh, welcome, Mr. Chaturvedi.
Thank you so much, sir. Thank you so much.
Thank you, Ravindraji.
Thank you.
So I now request Mr. Mahesh Chand Gupta again to introduce our lead speaker, Mr. Nipun Sanghavi.
Okay, thank Vivek. Mr. Advocate Nipun Singhvi, who's a practicing advocate in Gujarat High Court and other high courts and tribunals as well as Supreme Court. He is holding all law degrees and basically is FCA, CS, because of his ill health, he has got some tooth extraction today morning, tooth canal treatment today itself. So he could not, in spite of his efforts, I requested him to join for a few minutes even, but because of his very ill health, he is unable to join. So we have missed this great opportunity to listen to him today, but we will certainly try to bring him some other day. But he has his other has joined us short time at my request and his request. So Mr. Vishal Dave is already in the link meeting today. So I'll just introduce briefly Mr. Vishal Dave. Vishal Dave is a practicing advocate again in Gujarat High Court and various other high courts, tribunals, as well as Supreme Court. And he was also appointed as assistant government pleader before High Court of Gujarat. He has handled various civil, criminal, corporate, cyber tax litigations. And also he has been involved in many public interest litigations. He has handled and argued complex litigation challenging constitutional validity, such as merger of tribunals through Finance Act, National Estate GST Appellate Tribunal, Constitution of Authority of Advance Ruling under GST, RERA, even quorum of National Company Law Tribunal. He is also a regular faculty and speaker at ICAI, ICSI, nationalized banks, CAG, and various other corporates and tax journals in corporate professional bodies. So he is regularly invited for debate in electronic, print, and web media on topics of social and economic interest. Of late, I understand he has also fought many cases against IBBI disciplinary order and has been successful in getting favorable orders. So let us welcome Advocate Vishal Dave, and I will now request Mr. Vishal Dave to take over.
A very good evening to all my esteemed colleagues, and it's my immense pleasure today, because of ill health of my partner, Mr. Nipun Singhvi, I have got this opportunity to address on this very interesting and important topic, that is disciplinary proceedings faced by the insolvency professionals. So, before I begin my valuable contribution to this uh, seminar, uh, the for any professional to face any disciplinary proceedings is always challenging, whether it is a chartered accountant, company secretary, or an advocate. Now, as we know that in under the IBBI, we have the insolvency IBBI inspection and investigation regulations, which governs the entire disciplinary proceedings, wherein the body, that is disciplinary body, will derive the power from these regulations. As just the honorable member gave the overview, that first, before taking the cognizance of the complaint, they will conduct a investigation or inspection, and after, if they find that there is some material to take cognizance, and then they will issue a show cause. So first, the stage from the issuance of show cause to a IP professional, the proceedings begins of the disciplinary committee. Now, as soon as the show cause notice is issued by the board, the AFA, that is authorization for assignment of IP professional, get suspended. That we have one circular to that effect, that upon the issuance of a show cause by the board in the disciplinary proceedings, the AFA gets suspended. So this is a most vital point where once the show cause is issued and AFA is suspended, IP professional is not able to take any new assignment or in any assignment if he is appointed. So this is the first major breakthrough for the professional. So once the show cause is issued, then every professional gets some time, as per the regulations of 15 days time, to give a detailed response. Now, once the show cause comes, the show cause will have a explanation of the facts, charges levied against the professional, and the materials based on which the show cause is founded. So now, challenge to show cause could be on two ways. If you see, the proceedings, the disciplinary proceedings before IBBI is a quasi-judicial proceedings. So the nature of proceedings is summary in nature, where show cause comes, reply, then hearing, and then comes the final order. So in a quasi-judicial proceedings, we get only one opportunity to file a detailed response. So whenever a show cause comes, so the challenge could be on two grounds. One is based on a factual aspects, on facts of the case where any violation is alleged against the professional based on the facts. And second challenge would be the quorum of the disciplinary committee. So the quorum, I'll come to the next part. So once the detailed response is given by the professional, including all factual uh, clarification in a response, then the next stage comes of the hearing. Now, in a hearing before the IBBI disciplinary committee, a professional can represent his case by his own, or he may engage a counsel uh, to plead his case. After pleadings, the detailed order is passed. Now, as such, once the final order comes, so the order may be either the professional, there cannot be any, the complaint is closed based on the clarification, or what types of punishment will be granted by the committee. Monetary penalties could be imposed, or maybe the IP license is suspended for some period from 6 months to years also, or there may be a warning given. A warning means it's like a red flag to the professional that he should be careful. So these are the types of punishment is passed in the orders of IBBI. Sometimes it also has been observed by me in various orders passed by the disciplinary committee that for very small violation, and violation could not be any intentional, then also very heavy monetary penalty is imposed, maybe the twice of the fees, proposed fees of the professional for that assignment. So once the final order comes, then where to challenge that final order passed by the IBBI disciplinary committee? So there is no provision, as far the act is concerned, there is no provision of any appeal before any appellate forum. So the only remedy which is available for the professional to prefer a writ petition under Article 226 of the Constitution, a writ petition before the respective High Court where the jurisdiction lies. So the only writ petition is available to challenge the order of IBBI. Now, once we see the final order, the order is passed by a quorum. So, as far as my few cases are concerned where we have challenged the final order passed by the committee, disciplinary committee before the High Court of Gujarat, where we have taken one very good technical objection with regard to the formation of quorum of the disciplinary committee. Now, if we see the formation of committee under the IBBI, I think section 220 says that the committee should consist of whole-time members. So the word written is plural, members. So in many cases where we have challenged before the High Court, the order has been passed by only one member. So our contention before the High Court was that any disciplinary committee, the quorum could not be presided by only one man member of a committee. So either it could be 2, 3, or more in numbers, odd numbers. A committee, a disciplinary cannot be headed by only one member because there are likely chances of biasness against the adjudication. So that was the plea which could be taken, which we have taken before the High Court, and we have successfully got stay order on the implementation of the disciplinary order. So we have to always see before going into the merits and factual facts of the case, if we find that the quorum of the disciplinary committee is not proper, then there is a doctrine called quorum non judice, which says that if the quorum is not in accordance with law, then the entire adjudication of the process, of the disciplinary process, becomes void in nature. So this is a very highly technical ground which could be pleaded whenever any disciplinary order is challenged. Second, we also draw the analogy from various other acts like under the Chartered Accountant Act, or under the Company Secretary Act, or Cost Accountant. There is always a disciplinary committee in the Parent Act which is govern every professional. So with my knowledge, section 21 of the Chartered Accountant Act has a disciplinary quorum comprising of 6 members. So there is a president, vice president, 2 members nominated by the council, and 2 members nominated by the central government. So in a disciplinary committee, in case of a chartered accountant, company secretary, or cost accountant, there are 6 members. As far as disciplinary committee under the Advocate Acts have a 3-member committee, where 2 is a member which has been a member of the Bar Council, and 1 co-opt member is there in a 3-member committee. So before the High Court, when we have challenged the disciplinary order with regard to our defense of quorum non judice, we also pleaded before the court that every disciplinary committee has more than 1 member. So we show that there are 6-member committee or 3-member committee. There cannot be only 1-member committee because there are likely chance of biasness. Secondly, in a disciplinary committee, as the words have written in the statute, it could not be presided by a chairperson. It can be only a whole-time member. There is one judgment of Punjab and Haryana High Court wherein in a quorum of disciplinary committee, it was presided by chairperson along with full-time members. So that quorum is also not proper according to our, and this quorum issue is still matter is sub judice before the High Court, and we have challenged 3 orders successfully on that ground. So this is a technical ground where we can, without going to the merits of case, straight away based on quorum only, we have been successful in convincing the Honorable High Court that this order cannot be implemented, and it is a void order because the quorum is not in accordance with the law. Now, second point of challenge could be to the final order of IBPI that the disciplinary committee, while adjudication, our intention of the professional is very important. In our legal terminology, we say the mens rea as far as criminal proceedings are concerned. Mens rea means some very mala fide intention for doing any act. Now, sometimes in many cases, it happens that some violation of any procedure violation, there could be a procedural violation, there could be some observation given by the uh, maybe NCMT tribunal in some of the orders, based on which the either suo moto or by some complaint, the disciplinary committee take cognizance. So these are issues happening where, because if the intention is not mala fide and the profession is not intended to violate any of the regulations, then the disciplinary committee either can issue a warning or he could the proceedings could be dropped. So whenever we challenge at the stage of disciplinaring or the final order, we have to plead that the intention for any alleged violation against the professional was not intentional, and we have to also give the narrate circumstances, because even during the COVID period also, there has been many instances where during the process of CIRP, there are some minor violations to the procedural aspects, which is not even fatal to the case basically. So, and that could be subsequently also rectified by the professional. In those cases also, we have seen that disciplinary the committee has taken a very stringent view against a professional. So these are the aspects which have to be bear in mind whenever the show cause notices are being challenged. Now, as I said that the constitution is a very key factor in a adjudication process, and second, if there is any violation of principle to natural justice. Now, in many cases, what happens that they restrict our time of pleading at the time of adjudication during the proceedings before the IBBA also. They curtail our time. Sometimes they even doesn't allow the pleader to plead, and they always say no, we'll just allow the professional to plead the case. So if that instances happen, then again it's a violation of principle of natural justice, where we have not been heard properly. And whenever the order comes, so it is always advisable that after closing the oral arguments, every professional should file a very detailed written submissions incorporating all the legal precedents if they rely, including the paragraph, relevant paragraph to be quoted or maybe written in the written submissions. Sometimes what happens, we have been seen many instances, once the order comes, they have neither considered our submission or they have recorded a very contradictory stand which we have pleaded or our defense has been taken. Sometimes it has to also been noticed that the judgments we have cited on some precedent in support of our submission, even that has not been dealt. Now the law says there are caten of judgment on this aspect, that every disciplinary committee or maybe a forum who is exercising judicial proceedings, then the judgment, if cited by any of the litigant, has to be distinguished, whether if they are accepting it or if they are not accepting the legal ratio laid down in that judgment, they have to clearly spell out that why this judgment would not be applicable to the facts of the case. So that distinction is also not there. And some ratio, if it is directly applicable, then it also amounts to contempt before the forum if the judgments of the Supreme Court or the High Court or higher forum is not considered by the committee. So these are the many aspects where we found even sometimes what happens that in a order, some different facts are only recorded, which are not relevant to the facts of the case. That also we have come across. So this also becomes one of the very important ground that illogical reasoning has been given by the board, and the points which are not even applicable that has been discussed, and without considering our submissions, detailed submissions, the order has been passed. So on this ground also, this is also one of the very important ground which could be pleaded. And in many cases, the high courts have remanded back the matter for fresh adjudication by giving an opportunity to consider all the point and defense which has been raised by the litigant. So these are the few aspects and analogy where during the disciplinary proceedings we have to be vigilant, and we have to take care. And the procedural aspects of filing response after the show cause, detailed response. And in detailed response, it is advisable to take all factual contentions, including the legal points, and then in the submission and after the closing of oral arguments, written submission. This is very advisable for every professional. So this was my overview of the disciplinary proceedings which we have been able to successfully challenge, and this issue is still, the quorum of the disciplinary is still sub judice before High Court and before many High Court. Now the IBBI in all these matters carried by way of a transfer petition also before the Supreme Court to decide a very important issue with regard to the quorum of the disciplinary committee. But the Supreme Court has rejected the transfer petition of IBBI, and they have directed the Gujarat High Court, being the lead matter, to decide this issue. So now in the coming times, when the final hearing will be taken place of all these petitions, this issue maybe we are hopeful that the Gujarat High Court will decide finally. So this was my overview of the proceedings. If there are any questions, then we can proceed with that.
Yeah. Good evening, Mr. Vishal. This
Good
is Ravichandran.
Yes, sir.
Actually, I have also handled a lot of cases, and I know the SCNs were received by me also.
Yes, sir.
Some of the cases, what happens is, in almost in all my cases, I have not been, once I send the reply, so far there is no further action actually. Touchwood actually from 17 to 2024, this day, no action actually. But then the complaints were, the minutes were sent late. Actually, the minutes were first sent to the COC members for their in principle approval. Then we send it to the directors also.
Yes.
Once they approve it. This is one action. Second thing is that, the person, see, in one of the cases when the resolution plan was discussed with so many people, the applicant. So what happened? We had to make other people to wait in the one, including the director, because the other people are there. So the COC members wanted to discuss with each resolution applicant. So this he said, then there is he made a complaint that, there is something was going wrong and all. Then again, this, something he said we did not include. Some crap he was saying, actually everything we cannot include in the minutes. So like this, these so the point I'm trying to do is, trying to arrive at this, that there are so many complaints where there was no acquisition that, we have taken money, or, I have acted, taken money from the company or taken money from other person. No such complaint actually. All these were, sort of this complaint just to irritate. First thing he sends one reply. Again, after 3 months, he is asking his brothers who are also directors to IBBA. So again and again, I had to reply for that. And what happened is, the point is that I had to appoint an advocate to reply actually to kill that in the first instance itself. But then what happens is, when I take the fees from the company, this was approved by COC also.
Yes.
The directors object that this is a personal allegation against you actually. So why I should pay fees? Why you should take the fees from the company? I said, there is nothing like, personally I have taken anything or something like that. It is as an RP, you had put some, incorrect acquisitions. I had to defend it. I mean, this is because of I was an RP of this company. I had to defend this. Otherwise, there is nothing. So my request is that, whether unless a person is charged with taking money or something like that, the fee should be allowed by the corporate. I mean, what's your view, sir?
Fees regard to defending the cost of the litigation by the professional.
Yes, sir.
With regard to this.
Yes, sir. Yes, sir.
So what I understand that your question is that it should be reimbursed by the COC.
Company. COC is agreeing. COC says, yes, sir.
Yes. Sir, it will all depend on the basically the COC whether to reimburse, because I think you rightly said that in discharge of your legal function appointed by a tribunal.
Yes,
So
sir.
as you being a public servant,
Yes,
you
sir.
are defending. It could not be, according to my personal view, it could not be termed as a personal case basically, because
Yes,
in
sir.
discharge of your legal duty you are defending it. So even the disciplinary proceedings is a part of your legal duty, where you are being arraigned as an suspect, where you have to clarify and you have to face the embarrassment and the mental stress for the trauma by the unfrivolous allegations. Because sir, it is very easy, as you rightly said, that we file a one-page complaint and the cognizance has been taken. And in many cases, we have come across that we have got a copy-paste orders of some different facts without application of mind. So, sir, I think in my personal view, it has to be reimbursed from the CRP process only for a professional, unless there is a charge of any corruption. As I said, the mens rea, if any FIR has been registered or any criminal proceedings are initiated, then the aspect is completely different. But if you
Correct.
get a clean sheet and the proceedings are dropped, or after the final adjudication, if it is dropped and there is no any stringent remarks against you, then, sir, as you rightly said, it has to be reimbursed, because a professional cannot from his own pocket in discharging his own duty will do it. And in many cases we have seen the cost of assignment of a professional twice or the thrice the cost has been levied. And sir, for a professional who works for uh, uh, so many tenure of CRP process, see, it's a very long and stringent process if it is a CRP or liquidation. And at the end of the day, when for any minor violation where there is actual no loss basically, but any minor violation or any of the procedure aspect, the double the cost of the assignment is being imposed upon the professional. So it is very hard task. And so I, according to me, unless any criminal proceeding is initiated, it has to be reimbursed by the from the process,
Sir,
CRP process.
Sir,
sir,
one
here I
more
would
thing
like to
also.
build on. Sir, here I would like to build on Ravichandran sir's question. Now, the first point is that why should I answer the query of IBBI in the first place? Why I'm saying so? Now, if I may read the text of what is stated in section 218, it says, and I'm reading it, where the
Yes, sir.
board on receipt of a complaint under section 217 or has a reasonable ground to believe that any insolvency professional agency or insolvency professional or an information utility has contravened any of the provisions of the code or the rules or regulations made or directions issued by the board thereunder, it may, at any time, by an order in writing, direct any person or persons to act as an investigating authority to, to conduct an inspection or investigation by the insolvency professional agency or insolvency professional or an information utility. Now, the point that I'm trying to indicate is, as Ravi Chandran sir highlighted, same CD, different people making independent complaints. Now, in the first place, the onus of application of mind is on IBBI. So why should we not ask for an order under section 218? And if on the same subject matter, if multiple orders are passed, then this is suffering from non-application of mind on the part of IBBI. So we'll challenge them that, look, why are you initiating the same proceedings on different proceedings on the same cause of action? And IBBI has already
Uh,
suffered an order
yeah,
on grounds of non-application of
excuse
mind.
me, excuse me, sir.
Uh,
I'm interrupting in between.
yes.
Uh, I would like to request Mr. Vinay Singhania to moderate the question answer session so that the session can be managed well. Thank you.
Yeah, thank you, Vivek. Uh, I was just going through the questions which were asked by Mr. Ravi Chandran and Mr. Pratik Sarkar also. So I welcome each and every question, and we are fortunate that we have Mr. Vishal to answer each and every question. But before we start with the questions, let me clarify you one thing. We are here for the betterment of the insolvency professional code. Whatever has been mentioned in the IV code, we are not here to challenge the code. We are not here to interpret the code in such a way that RP should be the only beneficiary or something like that. So whatever is there, if we have anything in our mind that there should be certain changes in the code, then this is not the forum, and we are not here for the purpose of changing the code, or we are not for this particular purpose. We are asking that whatever difficulties we are facing. First of all, how can we prevent that one? And if certain things are there, then how to make IBPI understand that this is not because of the RP or the IP. So if you have any query as regards, I think Mr. Pratik Sarkar was asking that Section 218 is not giving the power. So let me clarify you that Section 218 has been made in such a way that IBBI has all the power, and even if there is no complaint as such from any of the stakeholder on its own, they can do any inspection, and they can make any investigation also, and only order can be passed only after the reply of the IP only. So we should restrict our question in such a way that how to prevent, and if any query has been raised, if any query has been raised, or if any inspection has been started, then how to reply to that one. If I am uh, on my way. So with these remarks, I request each and every person IP here to raise any query, and if Mr. Pratik Sarkar is there, he can alter his
Yes, yes,
query.
I'm here.
Yeah, yeah. You can alter your query in such a way that how to prevent, or how to make IBI understand that this is my situation. Because I have also received a couple of or three four queries in my case, and I have given my reply in such a way that IBBI, in fact, they have transferred it to IPA, and the IPA has been satisfied that your case is clear, and they have closed the case. So we should give the reply in such a way that they should close the case, rather than to contravene, or rather than to ask that you don't have the power. If I am correct, Mr. Vishal.
Uh,
Sir, if I may add one line here.
Yeah, yeah.
What I was trying to address is the issue of maintainability of the proceeding that has been initiated. Now, if the maintainability itself is vitiated, then there is no question of me answering the substance of the communication that is issued to me. And Honorable Bombay High Court has already quashed and set aside a disciplinary committee order against an insolvency professional only on the ground that the person who has signed the inspection order, he was not having the authority to do so. So I was addressing to that point, sir.
Mr. Vishal, please.
uh, sir, may I?
Yeah, yeah, please.
Yes, sir. Yes,
Yes.
sir.
Sir, my thought that whenever, sir, any disciplinary proceedings or whenever a complaint is filed against a person or professional, the best is that prevention is always better than cure. So, as the opening words of Section 218 is rightly said, that once the investigation or inspection is done, and if there is a sufficient material, then the cognizance will be taken and the show cause is issued. But before issuance of show cause, when a complaint is forwarded and a response is filed, as Ravi Chandra sir already told, that it is better that if any, as you pointed out, that it was not authorized. So this is one of the technical objection which certainly we could take in our reply to the complaint, all technical objections. But along with that, if we also clarify the factual aspect for any alleged violation, then it would be better that instead of a committee to take a cognizant issue show cause, and then we face the entire process, because once the show cause is issued, our AFA is already suspended. So it is better, because that will again we'll have a lot of trouble till the adjudication of final discipline proceedings are closed. So we will not able to take a new assignment. So if at a earlier stage also, if we give a detailed reply and if it is dropped, then it would be very useful for a professional that at that level of it is closed. Like if we go to a police station also, police will not register an FI immediately. First they will take a complaint, then they will take the statement recorded of the complaint and the proposed accused, and then if they find the cognizable offense is made out, then will they process for an FIR. So here also the process is very simple, because if a complaint which is of illogical and if we have a very strong to close it, then it would be advisable to give, though you are not bound to give an explanation, but if you give, then it will be close at that stage. Why to face a show cause and our license AFA is suspended? That this is my view on that aspect.
Yeah, true, true. Very, very much true. Any other question? we are open for the query by any member.
Yeah. Can I?
Yeah, please.
Vijayji? See,
Amazing.
first of all, let me uh, ask for excuse from my fellow IPs, because the question which I am not just asking is a real matter which has suffered by me, and it is not complaint from IBBI or action from IBBI. It is slightly different. Advocate Vishal is just to apprise what action to be taken. See, if the IBBI provision does not say if an IP, our fellow IP friend, does not cooperate with another IP, what to do? Suppose, for example, an RP does not hand over the asset records or anything of during CRP period to liquidator. Or maybe I don't know whether he has have the document or not, but he doesn't reply, not hand over. So what action can be taken? You are mute, Mr.
Yeah,
Dubey.
I think Mr. Vishal. Yeah, Mr. Vishal.
Sir, this is a very important
Yes,
issue.
Vishal.
It is being faced whenever, even after the from IRP to RP, or from, as you said, that once the CRP processes goes to liquidation, and if from RP to liquidator is changed, the handing of the all records, custody of the asset of the corporate debtor, this is a very important thing which has to be a part and parcel of the duty of an RP to hand over to the next charge. Now, sir, in case of in many instances, it happens that sometimes a record is not being given entirely, or maybe the custody is not handed over properly or within the time frame, since it is a time-bound law. Then, in such cases, if any new RP or a liquidator who face such issues and non-cooperation from the erstwhile RP, then the right course would be to file an application before the NCLT. And by filing an application, we have to state all the facts where we face the difficulty to comply with the procedural aspect for the non-cooperation of the erstwhile RP, because this will be very helpful to safeguard us for attracting any disciplinary action from the IBBI in case, because of this non-cooperation, if some procedural aspects is left out. So it would be the best issue would be to file an application stating all the facts and grounds for the non-cooperation by the erstwhile RP, sir.
Sir, again, with due respect,
Yes, sir.
everybody knows, all of us, what happens in NCLT. It doesn't come up even for months, and by the time liquidation is over. So my directly question is, can we not file complaint to, although it's very unfortunate to say that, but should we not file complaint to IBBI and IP in this case?
Sir, that can also be filed by one IP can also file against the erstwhile RP also, because that is also part of the duty, and if it breaches the procedure aspect, definitely a complaint would lie before the IBBI. That can also be filed and IBBI. But sir, the point is that IBBI will again, you file a complaint, cognizance will take a show cause was issued. So that is a different aspect. But the procedure difficulty is that the process has to be in a timeline thing. So if NCLT has to be also brought to the notice of the such any conduct which are faced. So that is also advisable that disciplinary complaint can also be filed. But I would suggest that what we normally advise, that NCLT should also brought to the notice of such aspects, sir.
Okay.
Otherwise, yes, for getting any extension or for any relief we want, that has to be a basis to safeguard us. That is the issue, basically.
Haji, regarding this one, yeah, just to extend the questions of Mr. Maheshji,
Yes,
I think I believe whatever query or whatever action can be taken in a legal field. What I have understood that for one particular issue, I cannot go to two different authorities. So regarding, I think in the case of IBPI complaint also, like in my case, I received 2-3 complaints, and all those complaints were already before the NCLT also. So I have just mentioned with the IPA against the so-called against this one query during the course of query raised initial query, that my whatever query has been raised by the claimant, the complainant has already filed before the NCLT, and the case is going on before the NCLT also. So I think let the NCLT decide what to do, and this is my position why I am doing this thing. So based on my this submission, they have closed this one. So basically speaking, if in this case of Mahesh Gupta ji, if the erstwhile RP or IRP is not cooperating, then the first obligation for the incoming RP to appear before the NCLT, because it is his primary duty to appear before to file a petition before the NCLT for any trouble. And if he's already filed before the NCLT, if he's again filing with the IBBI, then the IRP or RP who is outgoing or is surrendered due to NCLT order, he can simply say that NCLT is already looking after the things, and I'm giving whatever replies he's having, he can always submit that one. Yeah, I think you can.
No, Vinayji, I think what Mr. Vishal Dave said, I agree with him. It is a two different authority. NCLT is a different authority, as he rightly said. It is as per law, we have to file in the NCLT and to safeguard us. But to IBBI and IPA, because that is a regulatory body for IPs, and if any IP is not discharging his functions, duties, we must file complaint into that also. Both are unrelated and separate action, in my opinion.
Sir, I just want to extend, I want to add the question which Vinayji also asked. So sometimes what happens that some application, as Mr. Vinayji said, that it is pending before the NCLT for adjudication. And simultaneously, a complaint is also filed on the same facts which has been stated in the application. Now, sir, the NCLT is an adjudicating body. He is not a disciplinary, he has no powers. So sometimes if the facts are such of the complaint as well as the pending IA or any issue before the NCLT, and if that alleged violation is being successfully adjudicated by a NCLT, then even in many cases NCLT has also power to refer the matter to IBPI to issue disciplinary proceedings. And if that issue is still interconnected factually in any question of law or any error of law, then the right recourse for the disciplinary committee also to wait for the outcome of the NCLT adjudication. Because if that error of law for any, first, sir, the error of law and then the procedure enactment will come into force. These are the two very integrated part as far as legal submissions are concerned. So my request is, in that many cases where a complaint is filed on the pending IA, then as Binaji rightly said, we can also request the IBBI to keep in abeyance till this issue is rightly adjudicated by the forum, basically. Yes, sir.
Yeah. Shall I would ask a question to Dave?
Yes, sir.
Yeah, please, sir.
Yeah. See, in some of the matters, basically in the section avoidable application or 766 application, normally the bench asks IBBI to look into the matter. So in that case, I'm handling one case in which the bench, after hearing the matter under section 66 in the liquidation, is of the view that the CRP was wrongly started by the promoter. Let the IBBI inspect the case, and applicant, that is liquidator, is directed to give all details to it. And RBBI, after even giving 3-4 reminders, they are not looking into it. So in that situation, what RP can do this?
Sir, I think very interesting factual thing you have asked, that in such cases, as far as my limited knowledge is concerned, IBBI has no power to investigate for any malicious initiation of CIRP, basically. But if such order has been passed by the NCLT, and if it is directed to cooperate by liquid to provide the documents, then the best recourse would be that we should, as per the order, we should provide. And if IBBI is not taking cognizance of any complaint as per after the order, then it amounts to a contempt. But RP cannot do in that case, because it is for the regulatory authority to abide by the order passed by the NCLT for any direction. But I think in my limited knowledge, NCLT cannot issue a direction beyond the powers of the regulator to inspect in a malicious initiation for any proceedings. To my knowledge, sir, that would be an bad precedent would be set,
But in
basically.
that case, the liquidator or the IP, what he has to do is only transferring the order of the NCLT to the IBBI, and
Yes, sir.
IBBI has to act on his own, even if he
Yes,
is
sir.
not acting because of this action, the liquidation is not closing, resolution is not been completed. So
Sir,
this way, that is a
so
law.
the best, we are just a postman. We just have to pass on the message, or we can request the bench to issue notice directly to the IBBI for any personal appearance. In that case, that is only can be requested by the liquidator. Apart from that, if that process is getting delay, then NCLT may issue notice to directly IBBI and to respond to that person. Otherwise, it amounts to contempt of the order. That is also some other proceeding can be initiated by the bench itself.
Yeah. I'm also keen to close this matter.
Yes, sir. So
Thank
you
you.
can, sir, you can request the bench to file that the notice may directly be issued to the IBBI for personal appearance.
Yeah,
Or
yeah.
through,
I may request in the next hearing that you ask
yes,
direct
yes,
appearance to the chairman of the IBBI to
ye-
intervene in the matter, because
yes.
I have already given 2-3 reminders to all the executive director to look into this matter.
So you place that reminder on record of the bench and may request the bench that we have communicated in compliance of the order, and you
Okay.
request the bench that directly the concerned person of the IBBI may be directly issued notice and may give clarification, so that, because you may also request that since because of this pending litigation, the process is getting hampered, or
Yeah, yeah.
maybe you face any difficulty, then you can say the bench and request it in that way, sir, by placing the communication on record.
Okay. Thank you. Thank you.
Yes, sir.
Sir, if I may add one small
One,
point
one,
here.
I,
Sir, if I may add one
Yeah,
small
Mr.
point here.
Yes, sir.
Yes, sir. Sir,
sorry, I am here. Sorry,
in
I am
my
here.
view,
May I share
Yeah,
a thought?
Mr. Pradeep.
Sorry for interference.
yes, sir.
It's an
Yes,
interesting
sir.
question. May I share a thought?
Yes, sir. Yes, sir.
Mr. Binay, shall I share a
Yeah.
thought? I'm
Of
Jinan.
course, sir. Of course, sir. Welcome. Go ahead.
See, because I am here, I am audible because my video has some issues, so I stop it.
Of course.
But I am hearing it very interesting because I am I am hearing all these queries which is pushed to Mr. Vishal. I endorse the view of Mr. Vishal. This is very excellent views has been taken on it. But I think that this question has been lastly asked by somebody's name I did not recollect. That I mean NCLT has wrongly proceeded, because I think that a malicious prosecution, if there is an allegations by any complainant to the adjudicating authority has got jurisdiction to decide it, that matter by its own. It cannot send to, as Mr. Vishal has been observed, that it cannot send to the IBBI. IBBI doesn't and cannot take any consequence, that cognizance. That is why IBBI has not taken any actions. So that certainly what proceedings has been initiated by the NCLT is wrong and illegal and basically ab initio void. I think it is null and void, and I think it is, you can file an appeal before the appellate tribunal. That is the better way to court.
I think this was my discussion. See, as the officer of the court, I assisting the bench. As a duty of I have been directed to file the details with the IBBI, let the IBBI inspect and investigate the matter. That was the order written. So I have to follow the order of the court.
Yeah, it's an illegal. No, you are not bound by an obeyed an illegal order, certainly. Because under section 65, you point out the section 65 to the adjudicating authority or make an ask. Of course, the adjudicating authority has no power to review. I think that this is a better case to certainly it reach to the appellate tribunal, certainly. Because you have to take it, because you are an officer of the court, you have to aid the court, you are the liaison officer, certainly. You know that liquidator and you are very different. So you are facilitating the adjudicating authority. As adjudicating authority committing a wrong proceedings, certainly I think that is my understanding, is my experience is that it is you to correct it, because because it is a wrong order, it is an illegal order, finishy void, as Mr. Vishal
But
has
who is going
point
to
out
challenge? Who is going to challenge the order? Let the IBBI can challenge the order. How can I can challenge the order?
why the IBBI take the risk to challenge its order? Why? I think that they can ignore it. I
Sir,
think that IBBI, I think that it has been ignored by the IBBI. I feel so. Is it not? This is a good question. That's why I enter into. I'm very sorry to interfere, Mr. Vishal.
no, sir.
No, you are welcome, sir.
Honorable member has rightly said that as an officer of the court, we are not bound by an order. But see, once the order is a judicial order, so any of other as the other recourse, because it would be a very courteous act for any officer, because normally if day in day out we have to in all other assignment we have to appear before the same forum. So the another middle way could be that any of the stakeholder, like the any of the COC member or maybe another stakeholder suspended man, can certainly challenge that order before the higher forum, basically. So that could be the middle way. So apart from liquidator, any other stakeholder can also challenge that illegal order of investigation, or as you Mr. Sir said, actually that way. So this
Yeah,
any
yeah,
stakeholder can also.
Sir,
Sir,
if I may
I
add
don't
one
say,
small
I don't,
point to
sir,
it.
one more clarification, sir. I don't say that you cannot obey the order.
Yes,
None of the officer of the court has to obey an illegal order.
true, sir,
So,
true.
obeying an order of the adjudicating authority and not obeying an order of an illegal order of an adjudicator is entirely different. So it
Definitely.
will not report. You are correct. You are maybe interpreting like so. When a professional may not like so to have an interference, actually. But you are well aware that being an advocate,
Yes,
certainly
sir.
that you are an officer is even if an officer or a professional
True, true,
not
true.
bound by an illegal order because it is an ab initio void. Nobody is going to be questioned. He cannot, his professional cannot be challenged it. I only mention it that may not be literally interpreted that say. I never ever say that the order of an tribunal cannot be obeyed by a professional. I
True,
would
sir.
repeatedly say and I assert that an illegal order cannot be obeyed by any officer of the tribunal or any professionals. If I am at the hand of that insolvency professional, I will not obey it. I will point it out that this is I am not supposed to obey, or let me advise. This is not a question of review because you know when you ask for a review, then tribunal says that I don't have any power. He will not address that issue. He may not go into that issue also because first of all the adjudicator may think of that challenging my own order. So maybe an ego or maybe and because I am in the field certainly there may be a different view may be taken it. Of course, I don't want to have a confrontation with the adjudicating authority, but point it out that see, am I to obey because it is an obey because you pointed out section 65.
65,
Section
yes.
65 is clear. If it is a because I that is why I come in. I come in because you have to right way you have to proceed. We may not be mistaken of law. So when there is a power cast upon the adjudicating authority, adjudicate as to the malicious prosecution, if any, can penalize it. I also done it in my career. When an allegation is leveled against a company that is proceedings is here being initiated by maliciously, the Calcutta people knows it very well of me.
So
That is
sometimes it is, as you rightly said, sometimes we have to candidly really enlighten the bench, and I have to remind of their, I would say not remind of their
yes,
duties, but remind of their powers under the code, basically, to exercise
yes.
it.
Even
As you rightly
yeah,
said,
it is.
true,
Yeah, it
true.
is because we are saying that it is coins of two sides.
Yes, sir.
So I am not. I may not be supposed to skill man. You know the Lord Codaz's words.
No, no, no.
The judge must be a layman, not a skilled man. The lawyer must be a skilled man. So we have to
Yes, sir.
correct it when the professional says that something material because
True,
this
true.
section 65. I only come with the section 65. When you point out that there was an allegation that malicious prosecution CARP itself is wrong, then the IBB has to be initiated. Of course, the IBB cannot be initiated on the basis of the complaint because the disciplinary inquiry proceedings authority is the IBBI. You are
Yes.
truly so sorry for interference, Mr.
No,
Vishal.
Uh,
no,
so
sir,
I am
welcome.
no.
back.
No, welcome, sir. Just
Uh,
one more query from my mind. Just after hearing you, because your things were very clear, loud and clear. Just I wanted to add to that one. Uh, uh, if any false information, if any fraudulent way of starting initiating the CRP is there, can one not approach to the NCLT for punishment under section 75, 76, or 77? This just for the 7, 9, 10 against the 7, 9, 10. There are three sections: 75, 76, and 77. If someone is starting the CRP just for taking advantage of the IBC in a wrongful manner, can I not approach to the NCLT and ask for the punishment under 75, 76, 77? Sir, if
uh,
member judiciary here.
Yeah, so not a member of judiciary. Now I am in the very foot of Mr. Vishal. I am also
But we
similar to
always
Mr.
remember you
Vishal.
by that way.
Certainly, certainly, I am very because
Yeah, sir.
because you are from Kolkata. I
Uh-huh.
think that so it's my duty to enlighten or share my wisdom with what I learned. So
Of
you
course,
are
sir.
my brothers. You are my brothers, etc. You cannot go for a mistaken impression. And Vishal is rightly pointed out. But only I want to have a clarification. And this subject, I didn't interfere any of the questions which has been clarified by Mr. Vishal. Certainly has excellently clarified it also. And the questions Mr. Ravindran raised is also very interesting. That's why I thought of the one question and I back to the mic. I didn't hear about it. But this question, because it's, you know, the 74 and 77 are the punishment. And that is related because the proceedings, because when a proceedings is initiated maliciously, it's come to under section 65. In you, certainly may I take the section 74, the punishment for contravention of moratorium or the resolution plan. The moratorium is also inclusive of the proceedings. Certainly, this can be cognizance by taken by, you can file a 65 applications or section 11 application before the NCLT. Certainly, my understanding is that it can be because this punishment, because it is power under the court. So, adjudicating authority has been given the powers to give such a punishment, such a penalty to be imposed it. If it is certainly the where any creditor violates the provisions under section 14. So, judiciary under section, I think that you submitted 74, 76, and
75.
77. Is it? Am I correct?
Sir, 75. Section 75.
75.
Yeah.
75.
Punishment
75
for
is
false
the
information,
punishment for
punished
false
with
information,
application.
punishment by application. Where
Yes.
any person furnish information application made under section 7, false material particular, knowing false amidst the material, such person shall be punishable with fine which may not be less than 1. Yes, certainly. It's false information. Even any tribunal, any quasi-judicial authority can take actions. Even in the tribunal, even in the magistrate, even in the any quasi-judicial authority, suppose you submit a false information and a false affidavit is filed, you can be taken cognizance and taken actions against. And this punishment can be imposed. Definitely, the adjudicating authority has the jurisdiction. No doubt. My humble view. I think that Vishal can
Yeah.
enlighten you than me.
Yeah, yes, sir.
Thank you, sir.
Sir,
Thank you, sir.
sir,
Thank you, sir, for your comments.
Thank you so much.
uh,
Thank you, sir.
sir, this is a very important aspect with regard to any false statement or maybe incorrect statement or maybe some forgery has been done or any fraudulent act which attract any criminal prosecution. Now, sir, we need to understand that NCLT is a body where he cannot take a cognizance of an offense for prosecution. At the best, what NCLT could impose penalty. Now, suppose if NCLT is of the view of the finding that any fraudulent act or any penal action has been done, then as per he has to as per section 236 of the code, he has to refer to the this prosecution to the special court. The special court which is constituted under section 435 of the Companies Act. So special court is in a criminal is a designated special court under the authority for cognizance and prosecution of criminal offense. So NCLT can impose penalties, and but NCLT cannot prosecute and convict a person. So for any act of any false representation, perjury, or maybe a forgery in any extreme cases, then the NCLT with that finding can refer a matter to a special court, and thereafter a complaint by the special court can take cognizance and issue summons, and the criminal prosecution will thereafter will be carried forward.
One more minute, Mr. Vishal. Certainly, I am. You are very well correct. I didn't say that cognizance may be and a mistaken of words. Certainly, cognizance is for criminal prosecution. Even the cognizance can also can be taken in civil prosecution. Civil prosecution doesn't mean that a criminal that punishment. Certainly, you cannot punishment cannot be imposed. Here is section 75 only imposes penalty. The penalty provision certainly that complaint that I mean that a complaint can be filed under section 11 inherent power or under subsection 5 of section 60 and invoking the reading with section 75. Therefore, an initiation that I mean what I mean by cognizance means the initiation of proceedings. I may be mistaken, maybe I using that
Sir.
So
No, sir.
criminal prosecution is entirely different.
Yes,
You are
yes. So
correct. That is
NCLT
special
can do
court.
both the things, sir. NCLT
Both
can
sides.
also impose penalties, and if any act
As
of
well as
as well
but
as they have
I
to
thought that
refer.
I am mistaken.
No,
I
sir.
am
I
mistaken.
completely agree with
Yes,
your
yes.
view. But I'm just clarifying the aspect that NCLT can impose a penalty in terms of a monetary aspect. But if any
Thank you,
further
thank you.
prosecution has been taken, then they have to refer a matter before the special court.
Yes,
This
yes.
is this was my
Absolutely,
submission, sir.
absolutely,
Yes, sir.
absolutely
Yes.
correct. Absolutely correct. Yeah.
Yes, sir.
Thank you. Yes, back to Binay.
Yeah,
Proceed.
thank you, sir. Thank you, sir. Any other
So
query?
I
Sir, my
explore
query
your
is to Jinan sir. Sir, my query is to Jinan sir.
my
S-
God, Mr. Okay. Yes, sir. Come.
Uh,
Come.
yes, sir. Sir, here in Mumbai, we have a practice of challenging the processes to a writ code. Now, here in Mumbai, we have a judgment called Kamal K. Singh versus Union of India, wherein the Honorable Bombay High Court had ruled that NCLT rules are applicable in proceedings until and unless a separate rules are notified for IBBI. Now, my question is that given the situation that we just discussed, is it not advisable for an Article 227, because there are inaction by two authorities? One is wrong action and second is an inaction. Wrong action by NCLT, which is effectively overruling the order of admission, and second is inaction on the part of IBBI, which is holding up the entire CIRP. So rather than 60 subsection 5 or an appeal, is Article 227 an equally prudent option? That's my query, sir.
Article 227 is deals with the supervisory jurisdiction. Certainly,
Correct.
all the High Court has got supervisory jurisdiction over the adjudicating authority. So that adjudicating authority is not to act upon on their right, which they are obliged to do. Certainly, the cause of actions initiate. Certainly, you can file a 227. The Supreme Court has said that only under Article 227, as a High Court can have jurisdiction over the proceedings initiated by the NCLT. No other order can be under challenge because the appellate authority is the forum. So 227 can be rightly invoked is my humble view. Certainly. That if the IBB also is not initiating any proceedings or it is pending with and it is enacting it, certainly you can also file the High Court under Article 227. Definitely you can file it. But I understood from the question which
Yes, sir.
am I correct? Am I correct?
Yes,
Yes.
yes, sir. Thank you, sir. Correct, sir.
So I would like to add in further concurrence of honorable member views that as we said that in if there is an absence of any alternative remedy, as I just pointed out in case of a disciplinary order, the only option we have before the writ petition under Article 226 and 227, and there are canon of judgment which says that there is no absolute bar even in a case of an alternate remedy to approach High Court under the 227 or 226. But the only fact that for the entertainment of the writ petition, the only facts either has to be a violation of any fundamental rights or maybe some other violation where the writ petition could be entertained. So certainly the remedy is always open at the writ petition, but only will depend on the facts that what is under challenge, and if there are any efficacious and alternate remedies available or not. Even there are judgment to that effect that if the efficacious remedy, alternate remedies are, then also the writ petition could be entertained in very some limited facts also. That is I wanted to add.
Thank you. Thank you, Vishalji.
Thank you.
Thanks.
So we have one query in the chat box, although it is related to some other area. But since Vishalji is there, I think he will be in a position to light on the query. The person is asking that he was a liquidator, and during the course of liquidation, there was no outcome of any of the assets because there was no assets in the company, and the company was dissolved after the petition filed. And once the petition was filed and company was dissolved, but the liquidator could not recover any fees thereof. So the liquidator again went to the NCLT to recover the fees. But the NCLT declined the petition, and even in the appellate authority also declined the petition. So what action can be taken by the liquidator to recover the fees of during the course of liquidation? So what action can be taken?
So as far as the fees of the liquidation process is concerned, then as you said that it has been challenged before the NCLT and even the appellate forum has dismissed, then the right remedy would be to the judicial process only. It has to be challenged. Otherwise, because a fees part would be depend on the facts also, specific facts. Whether because now I think liquidation is also governed by regulations. So that aspect would be depend on the facts that it can be adjudicated through judicial process only.
I remember in one of the case in Kolkata, it is of in that case, one IRP was appointed by the NCLT itself, and during the course of the CRP process, he incurred many expenses which were altogether genuine, like valuer's fee, the fee of the transaction order, and the fee of the public announcement. And he continued for 6 7 months. Thereafter, one order came from NCLT only that pay to the pay to the RP 1 lakh, and then new RP was appointed, but he incurred the fees of approximately 15 lakh, which all were during the course of the CRP period, and all the bills and vouchers were available therein. The person, the the RP went to NCLAT also, and the NCLAT also declined his petition, and he had to suffer all the expenses on his own. So the things are there. Once the appellate authority has also declined your petition, then you don't have much things to do other than to approach and to incur more expenses towards the judiciary, and thereafter the outcome is not sure.
So this has been many issues with regard to the ratification of the expenses. With my limited knowledge of insolvency, all the expenses has to be ratified by the COC, which has been incurred by the RP. But in many cases, what happens that once the inspection has been done and when it is put forth before the COC declined to ratify or to pay back. So there has been a consistent disputes amongst them. Then in that case, if they are not ratifying the full amount or whatever the expenses has been with all the materials has been put forth before the COC, then certainly RP can file an application before the NCLT that these are the legitimate expenses, these are the supporting proof, and these are despite it has been put forth before the COC, they are not ratifying it as an expense. Or at the time of approval of resolution plan, this all expenses can also be put forth and can be part of the plan as far as the CRP expense is concerned. So these are the things, two things with my limited knowledge could be undertaken.
Any query from any person? Yeah, just another issue is here, like for the purpose of academic knowledge, like in the case of aircraft, one amendment was made, and during the course of the CRP process, the leasehold right of the aircraft can be cancelled. Earlier, the moratorium was there, and Section 14 has been made applicable to each and every person, so that the city can go ahead and it can come to a conclusion, and one resolution can come. But during the course of the Jet Airways, we have seen that whatever leasehold aircrafts were there, those leases could not be encashed, or those leases could not be cancelled. And the same thing happened in the case of, I think, first flight also. The lease could not be continued. The lease could be continued, and the lessor could not discontinue the lease only because the CRP process started. And what outcome has come that after this particular first flight case, the lessor started to discontinue the lease because they were aware of that once the company goes into CIRP, then it will be very difficult for them to cancel the lease, and there is rare chance that to recover any amount. So they started increasing their lease fee or cancellation of the lease fee. Then after these things, IPBI came out that whatever lease fee is there, since you are not in a position to make payment to the lease fee, then the lessor has the right to cancel the lease. So this is the exceptional case which we have seen in the case of aircraft only. But in case because I'm asking this particular question only in the light of the SpiceJet which has already started. The initiation has been done by a creator in the NCLT, and we are expecting order. It may come in favor of the SpiceJet or others also. So, what happens when the SpiceJet or any other airline company is going to the CRP and the lease will be cancelled in between? Then how the resolution applicant will come? Because there won't be any access.
Um, So very good and important question that after the imposement of moratorium during the CIRP, there are many occasions wherein any lease rights which has been utilized by the CD to keep the CD as a going concern. And sir, in my view, if during the CIRP process, if any contractual obligations or any lease rights being utilized by the corporate debtor for as a services, that during that period, whatever the contractual obligation says, that has to be paid to the lessor, because by the lessor, so that that part would not be governed as a CRP expense. So any things which has been utilized, any services, any aspect during the process by the resolution professional has to be paid. And if in the meantime, if any action is taken for cancelling the contractual obligation by cancelling the lease right or any services which has been being supplied, but then we can certainly file an application before the NCLT against that service provider, and we request that during the moratorium, these are essential services, keep the CD as a going concern, because as you said, if the lease rights been terminated, which are the only asset, then the no resolution plan will be come, and there will be no revival of the company. So, and if the claim, if there is any claim prior to the admission of CIRP, then the service provider or the claimant has to file a claim till the date of the admission of the CRP process. But after that, for a claim prior to the admission, he has to be file a claim. But during the period, if that service is he has to be used by the RP, then the contractual fees has to be paid. And if he is terminated, then he cannot terminate because of the moratorium, because that would be an essential service, maybe in a manufacturing unit or as you said in any process, to have a lively of the CD, so that a plan could come and the company could be revived.
Thank you, Vishal. Any query from any? So we have the last query. If any person is there, if any query is there, and thereafter we have to conclude because our time is over, and we are exiting. Means we had the time of 5:45, but we are already increased our time for 5:50. So if any last query is there, we are there. Otherwise, we'll close. Yeah. Thank you. Thank you. So no other queries there. First of all,
Thank you. Thank you, Vinayji. Thank you, Visalji, for this wonderful question answer session. It was really wonderful. So I now request Mr. Rajiv Kumar Agarwal to announce the next webinar of IPNet.
So I would like to thank to Mahesh ji for giving me an opportunity, because my learned brother and my partner Mr. Nipun is more knowledgeable and more expert on this subject compared to me. So I would request that in next session when he will be good, then it will be very enlightened to hear him on all these issues, because I tried all my endeavor with my limited knowledge of IBC, since I am practicing on other laws also. But since Nipun has also taught me the IBC, and he has only forced me to practice for NCLT as a litigator. So since it's a very corporate litigation, so I'm sorry for anything from my side, and thank you for giving such opportunity.
Thank you, sir. Good afternoon, everyone. I am pleased to announce our upcoming webinar titled Issue and Challenges in Avoidance Transaction. This insightful session will be held on 5th October 2024 from 4 to 6 p.m. and the keynote speaker is Uza Bedi. We look forward to your participation. Thank you.
Thank you, Rajiv ji. And I now request Rasmi Sharia for vote of thanks, formal vote of thanks. Thank you.
Thank you, Vivekji. Good evening, everyone. I'm Rashmi Chowcharia from IPNet East, and I'm very thankful to IPNet for giving me this opportunity to deliver the vote of thanks for today's event, handling disciplinary show cause notices, proactive solutions, and how to respond and resolve, which was the need of the hour, wherein we IPs can get answers to our so many questions. It was not just another webinar. It felt like the beginning of something much bigger, something that will resonate across our professional community for years to come. First and foremost, I would like to extend my heartfelt thanks to our own Honorable Chief Guest, Mr. K. Arjunan, former judicial member of Kolkata NCLT. Sir, having you with us today has made this occasion even more significant. Your wisdom, vision, and inspiring words have ignited a spark in each one of us. To our panelist, Mr. Advocate Vishal Dev, who on such a short notice has accepted our invitation in place of Advocate Nipun Singhvi and has given answers patiently to all the questions. Sir, you have rightfully done your job. And thank you for your valuable insight and guidance to all of us. You have enriched the discussion in ways that will undoubtedly influence our daily work. Thank you both for your dedication. I would also like to extend heartfelt thanks to our president, IPNet President, Mr. Ashish Makhija, who has initiated this and has given this platform of IP Connect, where we can connect with IPs pan-India and discuss the issues. Thank you, sir, for being that guidance force. Today, he is not present in this event because of his some commitments, but I know his wishes are always with us. I would also like to thank our wonderful coordinator and moderators, Rajiv Agarwal, Mahesh ji, Vivek ji, and Binay ji, for wonderfully moderating this session jointly and sharing your words of wisdom. And of course, a big thank you to Transition and our technical support teams. They work behind the scenes, but they are the backbone of events like this. I personally appreciate everything they have done to ensure the success of this event. Finally, to each and every one of you present today, you made this event truly special. Your enthusiasm, engagement, your questions have elevated today's discussions. Together, we are building something that will not only support our professional growth, but also drive innovation and collaboration in the insolvency sector across India. Thank you once again to everyone who contributed, participated, listened, and supported this incredible initiative. Thank you, sir. Thank you all.